we had a lot of self-doubt about what we were doing in Camden, because by and large, maybe this is a Caucasian view of the situation. We thought we were, to some extent, reinforcing patterns of discrimination and segregation by trying to maintain the neighborhoods in the city against the urban renewal work. At the time, there, in the wake of the riots of the 60s, there were national commissions commissioned to study this phenomenon of these riots. And one of those studies was the Kerner Commission. And they highlighted the fact that the country was dissolving, or had already dissolved, into this black-white, suburban white, black urban area, white flight, suburbanization, and whatever. So, that kind of was a little bit of a light bulb for us, and we started to look around, like why was that happening? And we went out and we talked to builders, why and they said, well, the idea of building lower income housing in suburban areas was out of the question. I mean, they would never be accepted. And the quote from them was, we build, what they want, where they want it. And that was my introduction to zoning. I didn't know what zoning was. I had really never heard of it before. And it was shocking to me that everything was so controlled, that municipalities just. I went out to Westlake Village at the time, which is in Los Angeles. I was interested in new towns. So when I was out there, I went and visited Westlake Village, which is a whole new town. It was, at the time, it's a huge community. It's like Reston, Virginia, Columbia, Maryland. And I had personally, I had kind of an epiphany that, my God, there's no lower moderate income housing here. They're creating an entire city without any poor people. And it didn't take too long for me to then consider the reality that that's exactly what was going on with suburbanization, and it was fostered by government, that the governments were actually proactively deciding to create these whole communities and to keep out and get rid of poor people. They had adopted a law in the late 60s authorizing municipalities to create these through zoning, these massive development areas. Well, a planned unit development turned out to be very similar to a new town, although on a smaller scale usually. So we sent Ken out looking for towns which were doing planned unit developments. And we found maybe 5 that were actively doing it, but Mount Laurel was really doing it. There's this town, out at exit 4 of the Turnpike. It was almost entirely rural at the time, but they had approved 5 planned unit developments. And they had laid out a program which, by the time it was over, was going to have 11,000 housing units. And it was easy to, Carolyn Greisman, who was our planner, was able to overlay that with the existing development. You could see what Mount Laurel Township was going to look like 10 or 15 years from now. And of course, there was no lower moderate income housing. So the Burlington office of Camden Regional Legal Services went out and started looking for plaintiffs in Mount Laurel and found that in fact there had been activity in this town. There was a minister, Reverend Stuart Wood, who had been active with a local minority community. And we go out and met with him, and it turned out there was this thriving, strong minority community in Mount Laurel Township that had been there since the Civil War. There was a Civil War graveyard there, black graveyard. There was a local church, which was the their church. They were very strong politically. They had been very active in the community. They were very proud to be citizens of Mount Laurel. And they had just been basically taken out politically by the development of what was then, I don't know if it's still called Ramblewood, which was basically the newcomers had taken over politically. And they had tried to get a 50-unit, I think, housing project built in what was called the Springville area of Mount Laurel, which is Hartford Road. And they had been basically blocked in doing that by the town, which wouldn't change the zoning, half-acre zoning or something like that. And so they had gotten seed money from the state to develop this project, and they had lost, and they were devastated. They were devastated politically because they had felt that this was their town, and they were shocked that they had been thwarted in doing this. So when we met with them, Mary Robinson was she was the matriarch of the Mount Laurel African American community. It was organized. Ethel Lawrence, her daughter, was this powerhouse of a young woman. They did not want to sue the town because they loved the town. And at one point, Ethel just turned and said, you just have, we told them what we thought we could do, which was highly speculative. I mean, we told them that there was no law favoring what we were proposing. But Ethel's attitude was, hey, we have nothing to lose. We're on borrowed time here. Her daughter was living in a converted chicken coop in the Springville area. She was devastated that they had turned down this project because she thought her daughter would be able to live there. Now we had a town, we had great facts, and we had insanely terrific plaintiffs. I mean, they were discriminating against their own people, and who had predated them in terms of occupying the town and residing there. So we decided to move ahead. We created 3 classes of plaintiffs, those who lived there. We were able to track people who had left because they couldn't afford to live there anymore. So we had another class of people who had left. And then we just took people from Camden who wanted to move to Mount Laurel, who we had actively represented before in our urban renewal litigation. And the times then, I guess maybe they kind of are returning a little bit, were highly volatile. We were concerned about the security of our individual plaintiffs, particularly Ethel and her daughter, who was a plaintiff, and Mary. So we decided we needed institutional plaintiffs that the other side would see was not going to go away. And so it wouldn't be worth it to them to scare or intimidate the individual. So we went to the NACP. We were very active already with these groups. They knew us and they had been involved with us, and we asked them if they would participate. So that's why it's called the Southern Burlington NACP versus the Township of Mount Laurel. That was the Burlington County branch, and the Camden County branch participated in CORE, which is Congress on Racial Equality. I don't even know if they still exist, but they were an active group at the time. They became a plaintiff. So we had class representatives of 3 groups and institutional plaintiffs, and we sued the town, saying that they were proactively discriminating against poor people, black people, and that was wrong. And we sued. And the town reaction to it was basically that it was kind of like a joke. Jack Gary was the town attorney then. Jack ultimately became a federal district court judge, an extraordinarily gracious, highly respected lawyer, high integrity. And but he thought it was, he said, you have no case law, the case law is against you. But what had happened before we filed suit, I guess I should note that we weren't completely flying by the seat of our pants legally, was a decision came down from the Supreme Court on D. Simone versus the Greater Englewood Housing Authority. And that was simply a case where a low and moderate income housing project, which had been sponsored by Englewood, so the town was in favor of it, they had given it use variances, was challenged by a group of citizens who did not want the low-income housing project built there. And they challenged the grant of the variance for it. It was a use variance. The case shot up to the New Jersey Supreme Court in like 5 minutes. It was incredible. I don't even know if it went to a trial court. And the decision came down affirming the grant of the variance. And there were two things that were significant about the decision. One was a throwaway line, which was completely unnecessary in the decision, where the Supreme Court said that even though the municipality had granted the variance, the court could not imagine how a denial of the variance could be sustained. That was a pretty strong statement because denials of use variances are routine, they almost never get overturned. And the most other significant thing about it is that the justice who wrote that decision, we did a little research about him, and he turned out to be one of the leading land use jurists in the country, a highly respected land use jurist. So, kind of our eyes kind of, we got very excited, and we thought we had somebody sitting at the Supreme Court who was open to this, certainly. And so in the litigation, now back to the trial, I submitted some discovery. I was good at this. My brother was the lead litigating attorney for Cahill Gordon in New York, which was a top litigation firm, and he was guiding me in terms of how to do some of this stuff and bombarding them with interrogatories and deposition requests. And Jack Gary called me up and he said, look, we can't bother. This is too ridiculous. But Judge Martinez said, hey, they're legitimate requests. And so Jack said, look, here's the deal. You can have a desk in the municipal building. You can look through all the files. Just do it yourself. We don't have the time or money to do this. And they literally gave me a desk. I sat in the Mount Laurel Municipal Building. I went through all their files. And it was, there was like a lot of stuff there. Not people saying, I want to keep the blacks out of Mount Laurel, but certainly there was a lot of what kind of people we want here and how we're going to do it with our zoning and how that's going to have this effect. So I prepared about a 30-page document of admissions. I don't know if you know what admissions are. They're demands to admit a statement of fact, which they either have to admit. If they don't admit it, and they should have admitted it, they can get into trouble. If they don't respond, they're deemed admitted, and it was all taken verbatim from the records I found. I was just quoting record after record. So they admitted it all. The trial lasted 4 days. Probably the shortest Mount Laurel trial in history. They usually go on for months. The town's defense was that this is ridiculous, legally. And Judge Martino ruled for us on two of our classes. One, that they had to help the local people who were living there. They had to see if they can create opportunities for people who had left to come back. But we lost on the regional theory, that they had a regional obligation and that they had to address the regional housing need. So they appealed and we appealed. The case passed by the appellate division, and it was heard as a companion case with another case which we didn't even know was happening, but was being done by a group called the Suburban Action Institute. They had sued Madison Township, pretty much the same grounds as we had, and they had lost. So the two cases were going to be heard together by the Supreme Court. And when they were called, Madison was supposed to go first. And I don't know, maybe it's too much in the weeds here. Norman Williams, who was the brilliant land use professor at Rutgers, who had authored treatises and this and that, was an amicus in the Madison case. He was going to be arguing there on behalf of, I don't know what, Rutgers University. Well, when they called the Madison case, the first thing that the Madison Township said is, look, we've changed our zoning. So it didn't take too long for the 7 justices to say, well, this case is moot, because the zoning has changed and we don't give advisory opinions. And we have this Mount Laurel case here, so we'll hear that. So all the Madison people left. I had come almost completely unprepared, thinking that I was going to be sitting and listening to the Madison Township case, and I figured after Norman Williams got done, there wouldn't be much I was going to add. So they called a break, and I went up to Professor Williams and I asked him, would he be willing to participate in our case? And I made a motion. Of course, he said yes, and I made a oral motion to allow him to act as an amicus in our case, which gave me some confidence. And then the argument started, and we ended up. It was a good argument. Went pretty well, and when the decision came down, we were flabbergasted. I don't know how else to put it. We were shocked. It was awesome in all respects but one. It really didn't provide a remedy. It just was a statement of the law as to what the municipal obligations were. And it wasn't a careful statement of the law. Trust me, at the time we thought it was fantastic, but it was, it didn't take long for us to realize that we were in for a much longer fight than just winning that case.